Oh man, we about to get into it. What's up? It's Cameron. This is Power Inherent in the People. You already know what's up. This is a community of like-minded individuals that are well educated, or at least we are getting well educated in relation to knowledge and the power in which we hold. Not power over others, but power the great creator has already given us and established by natural law and several other aspects. Today, I just want to get into a couple of things that I saw last night in relation to a judge and a channel. This channel, when I saw these videos, I was up late last night and I just commented on them. And I did some research just to understand a little bit more about the situation and the aspects of prosecutorial misconduct or misrepresentation by an attorney or just biased opinions from a judge that are not supposed to be within our court system whatsoever. And I think what we've done is we've allowed this court system to go so far that they are blatantly doing constitutional violations right in front of us, and we don't even see them. And a lot of the times it comes from the aspect of us hiring an attorney or getting an attorney, thinking they're doing the best for us, but in all actuality, they're really the worst option that we could have chosen. And this is today, what we're going to be speaking about is just that. The aspect of prosecutorial misconduct by prosecutors, of course, judges and their bias and how they should recuse themselves in the violations in which they do. And then, of course, attorneys just being horrible in relation to their jobs and representing the people the right way. And so, hey, man, let's get into it. I think enough long talk. Let's go. You know what I'm saying?
What would you like?
So, Judge, two things. I talked to Madam Prosecutor on this case, Judge, and I'm approaching on two things. One, bond reinstatement, and PC on this case, Judge. She and I have already discussed it on this case, and we just both want you to hear the PC, if we can, Judge.
Okay.
And then on the bond reinstatement as well, Judge. Right.
So officers initiated a traffic stop in Harris County, Texas for a vehicle having a fictitious plate bearing the word traveler on it. During the stop, the defendant refused to provide...
Traveler? Okay.
During the stop, the defendant refused to provide ID or insurance information, stating, "I do not consent to this." Officer attempted to remove the defendant from the vehicle, and defendant actively resisted by pulling his arm away from deputies until he was detained.
Okay. Tell me what.
So we look.
Okay, so I'm gonna stop just for 1 second. We have the basis right off the bat. And I think what you can see clearly already is a couple of mistakes. At least I do. The first mistake that I'm seeing on my behalf is the aspect that you've got this judge here laughing, ridiculing, mocking, trying to give an opinion as far as how he views things instead of being that trier in fact, right? The bias is already showing. But something else that's interesting is this individual's attorney. This individual's attorney is about to really be, I've never, the thing I'm noticing is that why isn't she here with any kind of paperwork? Why isn't she getting down to the nitty gritty?
That, I'm sorry, Madam Prosecutor, the interference with duties of public servant, Your Honor, even if my client is failing to give them that, then it is an arrestable offense. But in this situation, it is, Judge. However,
wait a second. She just said if the living being, this individual in which we see right here, refuses to give up his ID when there is no crime that has been committed, then it is an arrestable offense. Do you see now? Well, it gets worse. We'll keep going.
in this particular situation, he didn't interfere with anything in terms of his own arrest. I can, if it was a resisting or something to that effect, I can.
They're just trying to get him out of the car.
I don't disagree.
It's classic sovereign case where got the
Bias. Objection, Judge. What do you mean classic? My client is not any individual in which you can classify or put into some kind of pool or category. Judge, it seems to me as though you are being very biased at this aspect in relation to they're just trying to get him out of the car. What probable cause is there to get him out of the car, Your Honor? What crime? What reasonable articulable suspicion of a crime? What probable cause for a crime being committed, Your Honor? I mean, this judge is so bad, y'all.
License plate. Think that traveling by right is what I think how they term it.
Yes, that is how it is termed. You're exactly right. Look at both now of the judge and the prosecutor looking at each other, knowing that it is within probably their municipal and county code. Let's take a quick look at my municipal and county code. So let's take a quick peek here at what you might be able to possibly find within your own city, municipal, or county codes. As you'll see, all of these yellow things are highlighted because the judge is speaking correctly when he says it's open as a matter of right. So here we go in Pasco. Public street, open as a matter of right for public vehicular travel. Not driving, not transportation, not traffic, but travel. Open as a matter of right to public vehicular travel, public roads in Monroe, Washington, Port Townsend, municipal code. Public street means an improved street, whether improved or unimproved, held in public ownership, because who owns the roads? We do. Or control, either through deed or easement, conveyance, and intended to be open as a matter of right to public vehicular travel. Now, the point being, have you been able to go within your municipal codes, your county codes, to verify that your public roads, county roads, any way, street, highway, freeway, avenue, lane, alley, or court place is open as a matter of right to public vehicular travel? Seems as though we have the judge here trying to play words with the client. Which really makes me wonder, is this judge biased? Is he doing his job correctly? Is he giving advice from the bench and showing his bias? We'll get into that.
In this situation, Judge, and the reason I'm employing upon the court is, even from what Madam Prosecutor has seen on the video, they're pulling and tugging at his arm, which put my client in some fear. It was more than one officer. It was pretty.
But he still has a duty. If they're asking you to come out, they can lawfully do that. And there are videos.
You are right, Judge. They can ask you to do that. You are right. You are right. Whoever your name is, I don't know his name. You are right. They can ask. Why isn't the judge saying, Your Honor, you're right, they can ask, but they cannot force the individual out without probable cause or a reasonable articulable suspicion that any crime has been committed in the first place, Your Honor? Where is the due process in relation to my client's private property?
And go on YouTube, right? There are hundreds of videos where officers will literally destroy your car to get you out.
Right. And if they do so without probable cause of a crime being committed in the first place, when one stands on his constitutional rights, civil litigation should be brought to the forefront. This is the point. We are allowing poor representations as far as what they call a lawyer. I wouldn't even call her a lawyer. I think someone helped her get past. We'll keep going. I'll show you here in a second.
When you get into a pissing match with a person who has the power of arrest, who's going to win, Mr. Daly?
And that's why we don't argue with the cops no more. We're just from now on going to allow them to violate us. We're going to use the Eddie Craig script, move forward with knowing that we didn't commit a crime. We know what's up. We know the rules. Let them violate us and move forward into civil court. This is the only way. We have to stand on our rights and quit waiving them due to fear.
We don't disagree, Your Honor.
Right.
Oh, yes, we do disagree, Your Honor. We do disagree, Your Honor. Who is this lady?
You know what I mean? That's real life.
We don't disagree, Your Honor. I think
We do disagree, Your Honor. We do disagree. We disagree that that should be allowed in the first place when there is no probable cause or reasonable articulable suspicion, Your Honor.
under the circumstances of what actually happened, it was not Mr. Daly's position to resist or to interfere. That was not. He was concerned for his safety at that point. And actually, I don't know, did you hear that on the video? Right. And so
Look at these captions on this video. Such bullshit. Look, police aren't always in the right, but we have seen this again and again with SOV idiots. This is crazy. This is wild to me, because what it's showing is that it's showing to the public, first off, that it's okay for this judge to act like this, that this somehow is how court should go as far as representation is concerned in a statutory court, or regulatory court, should I say. And then, this is so bad.
reviewing the video, it was pretty quick, pretty brash. They didn't give him an opportunity to respond per the prosecutor. In this situation, it wasn't as if he was intentionally
Remember,
not.
this is just a mere probable cause.
Yes,
So,
Your Honor, I agree.
they ask you to come out of the car one time. Yeah,
No, I don't know. I don't know. This is the problem. We are not standing on our rights because we don't know them. Then we go over and we're hoping that if we pay someone to help us, that they are going to stand up for our rights. But this attorney is literally just holding this man. She's just holding this man. She is not defending this individual in his constitutional liberties at all. Where's the paperwork? Where are the motions? Where is anything?
it's really, that's, so, I think that there's enough probable cause to go forward now. The problem is, Mr. Daly, is that we revoke your bond. Your bond is set at 2501, and you've continually failed to appear. So, the case and the way that you've treated us, it shows me that you just refuse to accept authority.
Correct. That's right. That's right. We don't stand under anything because we don't have any authority over us. What do you mean? What does that even mean? You refuse to accept authority? Oh my gosh. I'm confused here, Judge. Who said that police are over me? Immediately, the judge should have said right then and there, or this individual's lawyer representation should have said right then and there, excuse me, sir, excuse me, Your Honor, if I'm not mistaken, the police are actually public servants. Isn't that correct, Your Honor? Yes, they are. Okay, so if my client was not involved in any kind of crime or harm being brought to another, there's no actual probable cause here for any of this to proceed any further. Do you understand oh my gosh, bro, I can't deal. We lack the knowledge.
How are we supposed to deal with that? How do we deal with that, Timberland?
Your Honor, the only reason I bring to your attention is I asked the court to take into consideration, we have a black male works every day who, and I hate to put that on the court, but I do in this particular climate, that has never been in contact with any particular law enforcement court system.
You're playing the black card now? So instead of using actual rules and things, principles, doctrines, filing motions, probable cause, due process, right to privacy, like what is going on here? What is happening? I am so confused.
And from what I can see and what I hear out here from a lot of my black male, and I'm sure it's common knowledge, is that because they are unfamiliar with the court system, they don't know, number one. Number two.
Yeah, they don't know that you're doing a horrible job. That you are really bad. They don't know their constitutional rights is what you should have finished saying, but you didn't because you're colluding with the state and the judge to make money off of ignorance, make money off of people who don't know. This is horrible.
They do come in contact with police, and my mother's assistant chief of police. So
my mother is assistant chief of police. Yep, that's the statement I was waiting for. So clearly, if she was a good lawyer, she would have been filing motions and arguing the right things. She's babbling, bringing up things like he's a black man. This is horrible. Like, this person probably got fed to pass the bar, and then got fed through the assistant police chief all of the, man, yo, this is bad, y'all. This is bad. You can see the corruption. You can see the corruption.
I can understand, even when I was younger, I was taught that there are certain things that you have to do with when a police officer even stop you on a speeding ticket. What we don't know is whenever these officers come up, when you're somebody who don't have the privilege of having a police officer as a parent, or who isn't familiar and is being raised in this particular climate, and seeing what they see on TV and seeing what they hear and everything.
What does that have to do with anything? Yo, I'm done watching her. This is so horrible. I can't deal with it no more. So what we're going to do here is I'm going to show y'all something. Watch this. So what I did is I pulled the transcript from the video itself and started to formulate some questions with ChatGPT. Within ChatGPT, I was really trying to focus on what can we pinpoint out in relation to the violations across the board in relation to this individual. Number one is the defense attorney's performance. The defense attorney failed to file motions and raise relevant constitutional issues. No mention of the fruit of the poisonous tree doctrine. The attorney did not file motions to suppress evidence based on constitutional violations, the Fourth Amendment regarding unlawful stop and search, and there was no motion to abate proceedings or challenge the jurisdiction of the court if defendant's travel was non-commercial and not subject to traffic statutes. She did not even invoke the rule of lenity whatsoever. The attorney failed to bring that up. The attorney conceded to probable cause. She conceded to it without challenging whether the officers lawfully initiated. She straight up conceded to it. Oh yes, they did have we get it. They did have probable cause. Who told you? What? Excuse me. No effort was made to invoke Supreme Court rulings affirming the right to travel, and that private travel in not involving commerce may not constitutionally require driver's licenses or insurance. Then the advocate effectively for bond reinstatement. The attorney relied on emotional appeals rather than addressing legal standards. She was blabbering. Now, on the judicial conduct and oath violations, bias and presumptions. The judge made bias statements about the defendant, such as, "You just refuse to accept authority." Quote, "When you get into a pissing match with someone with the power of arrest, you are nearly always going to lose." These statements suggest a presumption of guilt before trial, violating the defendant's presumption of innocence under the 5th and 14th Amendments. Now, improper legal assertions. The judge declared, "I don't care how you term it, driving or traveling, do not drive." Later in this video, he goes into, which I'm not even, should I get into it? Maybe so. Let's see if I can find it real quick. Hold on.
It is wrong. However, I'm employing upon the court to ask the court to take into a little bit of consideration. Number one, from his perspective, all defendants, can't just say this, but I do see that, from what I've known from this particular case and now in talking to him, I do believe that there is a sense of sometimes they just don't know. Sometimes they just don't. So I'm asking to reinstate his PR bond. I am now on the case. Well, you know about me. I'm a tight attorney. I run a tight ship. So, and by which of way I believe I can reach him in getting him to court and resolving this matter, which is what I talked to the prosecutor about when you were on break. It's like, let's just resolve this. Let's take care of this.
I'll buy it.
Yes, sir.
Okay.
Thank you, Judge.
I don't care whoever you have. If you flake on us again, that's 3 times. It's out. I'm not going to do it again. Do you understand, Mr. Daly? When you come to court, good things happen. When you don't show up and you continually do it, you can't expect good things to happen. Now, do you have a Texas driver's license?
Not right now.
You're not allowed to drive.
Right.
Hear what he said? Not right now. Now, right now. And homeboy says, "You're not allowed to drive." You're right, Your Honor. I am not allowed to drive. I don't use these roads, though, in a commercial capacity. Judge, Your Honor, can we distinguish the difference between drive and travel today, here?
You have a bond condition, and you've signed an affidavit with me today promising you're not going to drive.
Oh, he signed an agreement. Got him.
I don't care how you term it. Driving, traveling, however you're going to word it.
Uh-oh. I don't care how you're going to word it. So apparently definitions don't matter. And the actions in which one takes on the road when case law all across the board from the Supreme Court on is very clear on what it applies to. You can go and look into the statutes. You can go and look into the policies, guidelines, training manuals within the Texas State Troopers, your police departments, and again, going into the municipal and county codes, which allow you to see that the roads are open as a matter of right for public vehicular travel. I don't know who these people think they're fooling anymore. Like, you're not fooling us. And if you continue to violate people's constitutional rights, not even that. I think we need to actually bring forth complaints just on these alone. These are enough to get this type of travesty and treason out of our country. Okay? It's that serious, y'all.
Whatever you do, do not get into the driver's seat of an automobile, a motorcycle, anything with a combustible engine where you can get on the road, unless you have approval from us. Do you want to?
Unless you have approval from us. Boy, I don't know. Excuse me, Your Honor. Excuse me, Your Honor. My client has not been found guilty whatsoever. I think what you are trying to impose are constitutional violations in which you have no authority to do. At this point, we're going to have to ask that you recuse yourself. Yo, I'm figuring out what I need to do to file some. Yo, this attorney is horrible. And this judge and this right here is so against the Constitution. And I'm about to show you how. And just, you know what? Let's do it right now. Let's do it right now. Okay, so now we get into the second aspect of me getting a little bit deeper in relation to what I'm asking ChatGPT under a major prompt or a big prompt that I have initially. And we're going into judicial and prosecution related violations. So the first one is the judicial bias and prejudgment. The judge makes extrajudicial bias statements about the defendant's character, suggesting the defendant refused to accept authority despite no adjudication of guilt. The judge shows impatience and reliance on incidental references, e.g., go on YouTube, pissing match, rather than maintaining a neutral judicial demeanor. By presuming a certain type of defendant, e.g., classic sovereign case, the judge adopts a prejudicial stance that undermines the presumption of innocence. 2. Judicial failure to recognize constitutional claims. The judge dismisses outright the defendant's contention about the right to travel without a license or insurance, neglecting to engage with constitutional arguments or related Supreme Court jurisprudence. The judge also appears to endorse the notion that compliance with the police command is absolute, and he did, without recognizing a citizen's right to be free from unreasonable searches or seizures. 3. Overbroad and potentially unconstitutional conditions on bond. The judge imposes conditions beyond the standard scope, e.g., prohibiting all driving, traveling in any motorized vehicle without consideration of due process or less restrictive measures. No analysis is provided of whether these bond conditions are proportional or constitutionally sound, particularly given that no conviction has occurred. Prosecutorial overreach and potential misconduct. Now, the prosecution's theory may extend beyond the statutory limitations if it attempts to enforce licensing, insurance, or regulatory statutes intended for commercial traffic against a non-commercial traveler. No limiting interpretation of the underlying statute is considered, nor is there acknowledgement of established legal precedents that differentiate between private travel and commercial operation. Failure by the prosecution to clarify or confirm statutory authority for demanding licenses or insurance under these circumstances can be seen as an overextension of prosecutorial authority. Okay? Now, while previous commentary has addressed the defense counsel's failure to raise constitutional issues, challenge probable cause, argue fruit of the poisonous tree, or invoke the rule of lenity, there are additional significant omissions that further illustrate inadequate counsel. Number 1, failure to demand recusal or raise judicial misconduct. The defense's counsel never formally objects to the judge's biased remarks or seeks the judge's recusal despite the clear appearance of partiality. The lack of objection, the overreach in bond conditions, the absence of a motion to suppress or challenge the initial stop, no formal challenge to statutory interpretation or scope, failure to counter negative narratives or preempt judicial bias, no effort to seek clarification or limiting instructions, inadequate use of defendant's lack of criminal history or community ties, and failure to build an appellate record. Okay? Now the conclusion of this here, now we're going to go even deeper because it happened in Texas. So we need those violations, those codes. What all violations occurred in this less than 8-minute section right here. Okay? So the constitutional violations for this section alone, okay, literally straight up all the way. Number 1 is the 6th Amendment. Ineffective assistance of counsel. Defense counsel failed to raise critical legal issues, file essential motions, and provide a meaningful adversarial challenge may violate the defendant's 6th Amendment right Relevant case law, Strickland versus Washington, 1984. 2. 14th Amendment, due process and equal protection. The judge's biased statements and the appearance of prejudgment violated the defendant's right to a neutral and detached tribunal. Disregarding or dismissing constitutional arguments without a fair hearing does infringe on due process. The presumption of innocence. Judicial commentary that implies guilt or untrustworthiness before a finding of fact violates fundamental fairness under the Due Process Clause. Fourth Amendment violation as well. Unlawful stop and seizure. Now, if this initial traffic stop or subsequent demand for ID or insurance were not supported by proper legal authority and the line in which it has to go through first, any evidence obtained could be subject to exclusion under the Fourth Amendment. Of course, this is related to the doctrine of Matt versus Ohio and the fruit of the poisonous tree doctrine. Now, Texas constitutional and statutory violations that occurred just right here within this court setting, probable cause hearing. Number 1 is the Texas Constitution, Article 1. Section 9 protects against unreasonable searches and seizures analogous to the Fourth Amendment, providing a state-level basis to challenge the legitimacy of the stop. Section 10 guarantees the right of counsel and a fair trial. The failure of counsel to provide adequate representation violates the Constitution as well in Texas. Now, 2. Texas Code of Criminal Procedure, TTCP, Article 1.05, Rights of Accused, ensures the defendant's rights to due course of law and a fair and impartial trial. Judicial bias or refusal to consider constitutional arguments can violate these, or does violate these foundational rights. Article 1.051, right to representation by counsel. The defendant is entitled to effective counsel, not piss poor counsel, but effective. There was nothing effective about her ramblings of her personal opinions and her ties to the assistant chief of the police. Counsel's failure to raise constitutional objections, challenge probable cause, or file necessary motions constitute ineffective counsel. She literally agreed with the prosecution that it was okay for them to pull him out of the car and that he violated something by not giving his ID, not giving his information. Do you understand how wrong that is? That's what the judge did. She's like, oh, he was wrong. Go back and watch it. He's wrong. We're not saying that he wasn't. Yes, we are. We are saying that those cops were wrong. Well, he didn't do it, man. Okay, we're going to keep going. We'll file necessary motions constitutes ineffective counsel. Article 38.23 exclusionary rule states that no evidence obtained in violation of the U.S. or Texas Constitution or Texas laws shall be admitted. Defense counsel omission in moving to suppress unlawfully obtained evidence violates this procedural safeguard. Number 3, the Texas Transportation Code. Although requiring a driver's license for operating, we know what that word means now. Within both years in Black Law's dictionary, a motor vehicle, we know what a motor vehicle now. Both of those terms are in relation to using the roads in commerce. On public roads is well established under Texas law. Texas Transportation Code. That's why this transportation code is transporting goods, property, or anything else while using the roads. Y'all, come on, we've already gone through this. Y'all know what it states. The defendant's argument regarding the right to travel might at least have warranted legal scrutiny. The failure to raise proper statutory interpretation argument challenges the applicability of certain regulatory requirements that the defendant was not engaged in commerce, represents a missed opportunity by the defense counsel. Judicial conduct violations. So number 1, Texas Code of Judicial Conduct. Canon 2A, a judge shall comply with the laws and should act at all times in a manner that promotes public confidence in the integrity and impartiality. It doesn't say just integrity, it says impartiality of the judiciary. Making biased prejudicial comments or dismissing constitutional claims without reasonable analysis may constitute these canons. You simply saying that YouTube and all this, that has no relevance whatsoever to the legal canons, specifically 2A, that you are supposed to abide by. Canon 3B5, a judge shall perform duties without bias or prejudice. He's already violated. This case is out. Throw it out. It's done for. It's done. But because this individual doesn't know his constitutional rights, because he hasn't studied completely, he has allowed himself to become an infant and a ward of the state by allowing somebody else to represent him rather than him presenting himself and standing on all that he is, because he holds all power, because all power is inherent in him, right? When this judge says, you just don't seem to want to accept authority. Well, Your Honor, I don't think I have to accept any authority until I've done wrong or brought harm into another. If I am simply living my life free while not engaged in any harm whatsoever, why do you think one can tell me, man, yo. If the judge's comments are seen as revealing bias, well, clearly they are, or a predetermined view of the defendant's guilt character, a motion to recuse under the Texas Rules of Civil Procedure extended to criminal procedures by analogy, or Chapter 30 of the Texas Civil Practice and Remedies Codes, will be warranted. Attorney conduct violations. Sixth Amendment and Strickland standard. Defense's counsel inaction does meet Strickland versus Washington test for ineffective assistance if shown that the counsel's performance was deficient and prejudiced the defendant's right to a fair trial. Texas Disciplinary Rules of Professional Conduct, Rule 1.01, competent and diligent representation. She was not competent, nor was she diligent in any aspect. Counsel should possess or acquire the legal knowledge, skill, thoroughness, and preparation, which there was none. You can tell she did not cite anything. No rules, no procedures, no constitutional violations. She came in there and blabbed about her sister being the assistant chief of police. Man, that holds no legal. Coming in here talking about he's a black working man. What? Or that his lack of knowledge in relation to his constitutionally secured liberties. Man, what? In preparation, reasonably necessary for the representation. Failure to file suppression motions, object to unconstitutional conditions, or challenge the bias, or raise substantive legal arguments may contravene this rule. Rule 1.03, communication. Counsel must keep the client reasonably informed. A lawyer who fails to explain the basis for the charges or the possible constitutional defenses is not providing adequate counsel. Federal civil rights violations. This is what we are speaking on, is all of these violations are coming off just what we've seen. Just what we watched. We ain't even talking about what happened with the police. We're talking about right now just the aspect of how it is truly supposed to go, and how we need to educate ourselves more to get away from the aspect of not knowing. Like, we have to know our liberties, because if we don't stand on them, we waive them. We waive them. When they make a statement, like he said, you are not allowed to drive, and I don't care if you call it driving or traveling, and he is giving his biased opinions, you need to rebut that. Objection, Your Honor. I'm objecting right off the bat. We are getting it clear. So, 42 U.S.C. Section 1983, this civil action for deprivation of rights. If the defendant, which he did, suffered a deprivation of constitutional rights under the color of law, and if judicial and prosecutorial immunity does not apply, prosecutors have immunity for certain official acts. Judges have immunity for judicial acts, but certain egregious conduct may be subject to civil rights review. A civil action under 1983 might be contemplated. So the conclusion of all of this is, the transcript reveals several potential legal and ethical violations, constitutional infringements under the 4th, 6th, and 14th Amendments, violations of the Texas Code of Criminal Procedure and possibly the Texas Transportation Code regarding the proper applications of licensing laws, breaches of Texas Code of Judicial Conduct by the presiding judge, failures of defense counsel under the 6th Amendment and Texas Disciplinary Rules of Professional Conduct, and the specter of professional prosecutorial overreach implicating the Due Process Clause and fundamental fairness principle. By referencing these constitutional provisions, statutes, and conduct codes, one can identify legal grounds upon which the defendant's rights have been compromised and upon which counsel was obligated but failed to act. So that's one of these videos, okay? There's going to be another very soon that I'm going to be uploading. Maybe tomorrow, maybe Monday, okay? But I wanted to bring this to your attention to notice that This ain't even deep into ChatGPT as far as the O1 model and what we are going to be able to do to help people. Okay, we're going all the way around now, y'all. We not finna play no more. We have to realize our liberties. We have to stand on those and stop playing with people, because this next one's gonna get even worse. The next one is actually an attorney who does stand up, okay? And you can see just how flip-floppy this judge gets as far as he shuts up and starts to obey when things are brought up correctly. And it's one of the most fascinating things that we can cross-reference to see the difference between one lawyer and defendant who doesn't know versus a lawyer who knows and will defend very heavily and shut that judge up. Same judge, by the way, too. So I'm just going to say this at the very end of this. Hey, y'all be sure. The right to travel course is now free, y'all. Okay? It wasn't. That's free. The description, or the link is in the description. I also wrote a book. I just released it last month in November. It's called The Last Tread. It's about all of my experience over the past 9 years traveling with no license, no registration, no insurance, and no title. Okay? That's how it goes, y'all. And then what else do we got? We also got the Traffic Law Reform Petition, which is a campaign that we have developed. All you have to do is go to change.org. The link is in the description. You sign it. And what we're going to do is we're going to forward all of that over to our representatives, our legislators, all across the United States to get traffic law reform and decriminalizations of all of that. Because remember, traffic law is in relation to commerce, and we need to start rectifying and getting this addressed, because we're seeing too many lives being lost. And then one other thing we got going on that starts tomorrow. Now, if you're watching this today on Saturday the 14th of 2024, tomorrow at 8 a.m. Pacific Standard Time, we are beginning the most coolest project ever, which is Operation Wise Dome. And Operation Wise Dome is amazing because we have 20 foundational members who are going to donate $10 every month to get ChatGPT's full O1 model, unlimited use, to formulate these types of things: overviews, analysis, deeper. And this is nothing. This took me 5 minutes. I could literally take another 10 to 15, 20 minutes and get really deep to draft up a complaint based on this transcript alone, naming all of the parties involved in their constitutional violations, to pursue a state or federal civil suit. And this is the point where we're at. We don't have to depend on these horrible attorneys and lawyers anymore at all. We need to depend on ourselves, and it's all based on knowledge, with respect, honor, morality, integrity, all the way. Right? Allowing the great creator to work through us, because I am you and you are we and we are us. All a part of the great I am. And all power is inherent in us, we the people. I love you. I'll see y'all tomorrow. Bye.